All right, future paralegals, let's get into it. We are tackling one of the absolute most important chapters for your licensing exam and honestly for your entire career. Chapter 12, Advocacy. We're going to break this down exam style so you can spot the issues, know the rules, and absolutely nail those questions when the clock is ticking. Okay, let's do this.
So first things first, what even is advocacy when we're talking about your exam? Look, it's not just about giving a fiery speech in court. It's really the set of professional conduct rules that dictates how you have to act whenever you're representing a client. Getting this stuff right is so critical, not just for passing this exam, but for building a solid reputation of integrity from the very first day you're licensed.
And this right here, this is the fundamental balancing act you're always going to be performing. Yes, of course, you have a duty to be a fierce advocate for your client. But, and this is a big but, that duty is balanced by your higher duties to the public and, most importantly, to the administration of justice itself. You know, the trickiest exam questions are going to test you on exactly this, right where those duties might seem to conflict.
Okay, let's get practical. How do you actually spot an advocacy question when you're in the middle of the exam? You've got to train your brain to recognize specific fact patterns. When you're reading a scenario and you see any of the things we're about to talk about, a huge neon sign should just light up in your head that says, Chapter 12, Advocacy.
Think of this as your mental checklist. Your client says, hey, let's not tell them about that document. Boom, that's trigger number 1. The paralegal on the other side is yelling or being totally rude in an email. That's trigger 2. You get a surprise piece of evidence the night before a hearing. Trigger 3. Your main witness pulls you aside and says they're going to embellish the story a little bit on the stand. Whoa, that is a massive red flag, and that's trigger number 4. You see these things, you immediately think Chapter 12.
All right, so you've spotted the issue. Now what? Let's talk about the core rules you need to know to solve the problem. There are a handful of foundational rules in this chapter that you absolutely have to, have locked down. These are the big ones, the ones that are almost guaranteed to show up on your exam in some way. Seriously, you've got to know these cold.
First and foremost, the duty of candor. Now, the key words here, especially for your open book exam, are absolute duty. That means there is zero wiggle room, and crucially, including by omission. This is the part that trips people up. Not telling the tribunal something important that you know they should know, that's just as bad as actively lying to them. It's a super common exam trap.
Next up, a rule that causes a ton of real-world professional conduct complaints, which means, you guessed it, a ton of exam questions. You simply cannot call, email, or talk to the opposing party directly if you know they have a paralegal or a lawyer. The only way around this is to get the consent of their representative first. It's a black and white rule, so make sure it's burned into your brain. So, knowing the main rules gets you most of the way there, but if you really want to ace this section, you need to understand the exceptions. The examiners just love to test these little gray areas and nuances because, well, that's what separates someone who kind of knows the material from someone who really gets it. This table shows you 2 of the biggest ones. So, like we just said, you can't talk to a represented party unless you have their paralegal's consent. That single word, consent, that's the key. Second, you can't state your personal opinion to the tribunal, but you can, and in fact, you should, make strong persuasive arguments that are explicitly based on the evidence. The difference between those 2 things is absolutely critical.
Okay, let's talk about the mistakes people make when they're under pressure. You know, the common traps. Knowing what these are ahead of time is your best defense against falling for them on exam day.
This is a classic trap. The scenario will have the opposing paralegal making a mistake. They get a date wrong or misstate a number. And your gut instinct might be, oh, I should be courteous. I don't want to call them out. Wrong. Your duty of candor to the tribunal is higher than your duty of courtesy to your colleague. You have to correct the record. Your highest duty is always, always to the court.
This question, it really gets to the heart of another common confusion. A strong argument is always tied to the facts. You'll say things like, based on Exhibit A, or as the witness testified. An improper personal opinion is when you inject yourself into it. I believe my client is telling the truth, or I think this is what happened. The second you hear yourself saying, I believe, or I think, you know you are on very, very thin ice. Stick to the evidence.
So, why does all this matter so much? I mean, what's the big deal? Well, the consequences for breaking these advocacy rules are severe. They're serious for you and they're serious for your client. This is the so what of this whole chapter.
Yeah, this is not just getting a little slap on the wrist. You could face a formal finding of professional misconduct. You could get suspended from practice. You could even be ordered to pay the other side's legal fees out of your own pocket. And maybe worst of all, your mistake could cause your client's entire case to be thrown out.
The stakes here are incredibly high.
And that really brings us to the final, crucial takeaway. If you are ever in doubt about what to do, just remember this. Your ultimate duty is to the integrity of the justice system itself. That comes before everything else, even your client. In the long run, your professional reputation is the single most valuable asset you will ever have. Protect it. All right, now go hit those books, and good luck.